Does the city breach an implied covenant of good faith and fair dealing when, after selling taxi medallions, it then changes the rules to allow Uber and Lyft to compete against them? To find out, you have to read Singh versus City of New York. But it's 12 pages. Don't have time for that? I've got you covered. This is Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on the case of Singh versus City of New York. This can be found at 2023 New York Slip Opinion 02141, published by the New York Court of Appeals on April 27, 2023. The issue in this case is, did the City of New York breach an implied duty when it sold taxi medallions for yellow taxicabs and then soon after made beneficial rules for Uber and Lyft drivers? To understand what's going on in this case, you have to understand 3 things. 2 of them are law and 1 of them is fact. First of all, General Business Law 349, GBL 349, says it's unlawful for deceptive acts or practices in the conduct of any business, trade, or commerce, or the furnishing of any service in the state. So deceptive practices or acts are prohibited by GBL 349. The next thing you have to understand is CPLR 3211A1. 3211 is a summary judgment statute. And 3211A1 says that you can move for summary judgment, which is winning a claim without having a trial. Number 1 is on the grounds of documentary proof. And number 7 is pleading fails to state a cause of action. So if you say that the plaintiff doesn't have a real cause of action here, they haven't articulated one, that's summary judgment under 3211 A7. And if you have documentary proof that proves your case, it's A1. The third thing you have to understand is the Taxi and Limousine Commission is a commission under the state of New York, under the city of New York, that runs all the cars for hire in the city of New York. So they have, over the history that they've been around, they had yellow taxis, which are the only vehicles that are allowed to pick up hailed passengers. So if you're on the streets of New York City and you go, taxi, the ones that are allowed to pick you up are yellow cabs, and they're usually actually yellow. And then there's something called black cars, and black cars are usually the fancier cars. And those cars always have to be prearranged fares and have a dispatch station. So those are 2 kinds of things that TLC has historically regulated: yellow cabs, yellow taxi cabs, and black cars. And then Uber and Lyft came out, which are smartphone applications where you can use your smartphone to call a car to where you are. Those TLC categorized as black cars because they're really technically pre-approved, prearranged cars. Okay, that's the background. What happened in this case? The facts are the plaintiffs are purchasers of yellow taxicab medallions. And because taxis have the monopoly on picking up fares, historically, taxicab medallions, which are physically a medallion that's attached to the hood of a taxicab, have been extraordinarily expensive, over millions of dollars. So in 2013, the city of New York, TLC, had an auction, and the plaintiff bought 14 taxi medallions for an average of $1.34 million per medallion. At the auction, they distributed an auction form, and the form had 3 big disclaimers. The first one said, the buyer is not relying upon any statements or representations about the amount of the bid. The second one was that there are a lot of disclaimers, but the second important one here is that there's no representations being made as to future rules that TLC may use with respect to taxi medallions. And the third is that there are no warranties, express or implied, made apart from a warranty of clear title for the taxi medallion. So, plaintiff buys these, and then a few months later, they change the rules and allow a lot more Uber and Lyft drivers to operate in the city of New York. Now, they're still not allowed to pick up people calling for taxis, but people are using these Lyft and Uber apps a lot more. So it reduces the value of the taxi medallion tremendously. Plaintiff sues on 2 grounds. First, under GBL 349, saying this was a deceptive practice by TLC, and secondly, that the TLC violated an implied covenant of fair dealing. They moved to dismiss. The defense moved to dismiss, and ultimately goes to the Court of Appeals. And this is what the Court of Appeals says, and they're holding. On the question of was there a breach of implied covenant of good faith and fair dealing, they say, all contracts imply good faith and fair dealing. What that means, it's a pledge that neither party will do anything which will harm or injure the rights of the other party to receive the fruits of the contract. But it cannot be used to imply anything that's inconsistent with the actual agreement of the contract. And here, the disclaimers, this is a case about the strength of disclaimers. The disclaimers made any implied covenant inconsistent with the agreement because the disclaimer specifically said we are not making any representations, express or implied, about the value of the taxi medallions or anything we're going to do in the future. So they say that there is no implied good faith or fair dealing claim that can lie here, so it's dismissed. And as to the second part, the GBL 349 claim, they say this is directed at wrongs of the consuming public. It's a consumer protection thing, not a statute that can be used by sophisticated, complex buyers who have experts at their disposal. And the buying of a taxi medallion for millions of dollars, is a sophisticated transaction. It's not like buying gum, which is what GBL 349 is meant to protect. A consumer transaction, not a sophisticated, complex transaction. So they dismissed that as well. Plaintiffs lose on all counts, and that's the case of Singh versus City of New York. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.